Thank you for joining us for the Creators Roundtable Lunchtimes. Oh, it's no longer the lunchtime special. I wrote this like a long time ago. Creators Roundtable's CR60 special featuring attorney Katie Lane. I'm your host, Nancy Russo. The Creators Roundtable is an online community of creative business owners who meet in a monthly moderated session that help members set measurable and attainable goals, such as creating marketing materials, streamlining working with clients, firing clients, telling clients you love them, and more. Registration for our next term is happening now through December 21st. To see what our session's like, you can visit creativesroundtable.com/about. The link is on the side. I want everyone to mute themselves, and when you get to the Q&A session, you can raise your hand, as we have lots of people here today. I first came to know Katie while I was watching contracts for creative freelancers on Skillshare. Katie helps freelancers and creative businesses handle their legal problems and negotiate like rock stars. Katie will be answering pre-selected questions about negotiations and how contracts work. And remember, this is not legal advice. And now I will turn this over to Katie.
Thank you. That was a lovely introduction. And yes, it's not legal advice, it's legal education. The only reason it's not legal advice is because you're not my client. But I am hoping that the stuff that we talk about today will be helpful for you, that you can use it in your businesses, that it will help you ask smart questions from the professionals that you work with and help you manage your clients effectively. That is my goal. So Nancy shared with me a couple of questions, a lot of really good questions, by the way, thank you, that you all had asked prior to this session. I like kind of doing this in an AMA style, but because I had your questions beforehand, I sort of organized them. I thought that could be fun and interesting. So let's see. I don't think I can share my screen, but it doesn't really matter. The different sections that we're going to be talking about are...
Katie, on the very bottom, in the middle, there's an arrow that says share, and you can share your screen.
I can share my screen. How exciting. Let's see. We'll do this. And... so, okay, cool. So the all of the images, by the way, that you're going to see, I got from Unsplash, and so I have credited the photographer somewhere on the screen. So if you like a photo, you should be able to find it by going to unsplash.com. So one of the subjects that you all asked a number of good questions about is how many contracts? Like, should I have a contract, and should I also have my client sign my contract and I sign my client's contract? If I'm going to do several projects with a client, should I have a contract for each project? Or should I just have one contract and then do something else for each of the projects? Those are really good questions. I get them more often than you might think. And my answer to you is that you want one ring to rule them all. A contract is describing a legal relationship between two parties. And in your businesses, those parties are you and your client. And when I say your client, I mean the company that is hiring you, the company that is required to pay you, the company that you are making things for, not necessarily the individual that you're going to be working closely with. So the contract, because it is describing the legal relationship, and that relationship is going to stay the same over the course of many projects, we really only need the one contract to describe that relationship. When it comes to having separate projects, we can use either statements of work, or sometimes people like to call them project scopes or briefs, to describe the particulars of that project, so that the client understands how much it will cost, what its timeline will be, the services that are included, the services that are excluded, that's an important part, and any other details that are project specific. So think of it as having one main document, one ring to rule them all, and then all of these other SOWs or project documents are little rings leading up to the one main ring. So they are connected to the primary contract, but they're each individually describing a project. The other thing that you don't want to do is have several contracts for the same relationship. For instance, I had a client recently who said, I'm working with this new company. They gave me their MSA, which is Master Services Agreement. Should I also give them my Master Services Agreement and have them sign that? And the answer to that question was no. You don't want to sign two separate agreements, because if you sign those two separate agreements, remember the agreement is describing the legal relationship. And if you have two separate agreements and they conflict, then you have confusion over what that relationship really is. So you only ever want to have one services agreement for the relationship itself. There might be additional documents that you are signing. So there might be those SOWs. There could be an NDA, a non-disclosure agreement, something regarding confidentiality. There could be additional legal documents that are in play, but really you should only have that one services agreement. I do recommend that if you have a primary agreement that's going to cover a lot of projects, that you review it at least once a year, because you want to make sure that the terms that you agreed to are the terms that still make sense for the relationship. If you've signed their agreement, chances are they're not going to let you change a whole lot, but by reviewing it, you can remind yourself of what the terms are in that relationship, and you can make decisions about whether or not you need to change your policies or procedures in the statements of work that you have for projects because of the terms and what you've learned about working with that particular client. The other thing that you want to make sure that you do is when you have a statement of work, SOW, or a project document, that it references the contract that is governing that legal relationship. So the contract that you signed with the client, you want it mentioned in the SOW. And usually the way that we do it is right at the beginning. It says this statement of work is governed by the Master Services Agreement that was signed by the parties on this particular date. And the reason that we do that is you're leaving little crumbs for somebody who needs to interpret that document later on, so that they know that if there is something missing from the SOW, or if there's a question that they have about the relationship that they can't answer with the SOW, they can go back to the contract and get it answered there. And one thing that's related to this is, because of what a services agreement is doing, because it's describing that legal relationship, its terms are going to be more generic, more universal. So they're going to be things like confidentiality requirements. It's going to be things like you're an independent contractor, you're not an employee. It's going to address whether or not you can use subcontractors in the work that you do, and if you can, how you can use them. It will probably have some information about payment terms, but it shouldn't have specifics like how much a project is going to cost, if the purpose of the agreement is to cover a lot of projects. If the purpose of the agreement is just to cover one project, it's okay if it gets specific, because it's basically combining the services agreement and the statement of work into one document. But if you want that services agreement to cover several projects, you don't want it to get too specific, because you don't want to limit yourself to those terms only. And one of the reasons that that can be hard is oftentimes when you're signing the services agreement, you're thinking of a particular project, right? You're thinking of that first project that you're going to do with the client. And one of the things I encourage the folks that I work with to do is to step back and think of it. Think of the terms in that contract, not only just in relation to the project that you're contemplating, but the type of relationship you want to have with your clients. Do the terms in the contract support that kind of relationship. And if you, by stepping back and thinking of the bigger picture, sometimes you can notice things that are out of whack, or notice areas where the terms are getting a little too specific. The next series of questions were all about signing documents. And I like these questions a lot because it's the type of thing that you think of if you are using a contract practically. It's not the type of thing that lawyers talk about a whole lot, but it comes up. I get questions about signing contracts fairly regularly. And one of the first questions was, who should sign the contract? Who on the client side should sign the contract? And does it impact whether or not the person you're working with has to follow the terms of the contract? So my understanding of that question is, let's say you're doing some graphic design and you're working with the marketing department, but the person who has signed the contract is either in the legal department or is a contracts manager, is in accounting, but is somebody who is outside of the marketing department. Does the fact that the marketing department hasn't signed the contract, does that impact whether or not they have to follow it? And the answer is no. And part of how you can understand this is to rewind to that weird idea that corporations are people. And because we've decided that corporations are people, but they're not actually humans, we need them to be able to act somehow. And the way that we get them to act, the way that we get them to agree to things or to engage in projects, is by having agents. And those agents are the people who are authorized to make decisions on behalf of the company. So for instance, when somebody from the legal department signs a contract on behalf of the company that they are working for, they are not signing to say that they personally are agreeing to the terms of the contract. They're signing to say the company is agreeing to these particular terms and the company will follow these terms. And I am signing as somebody who is authorized to speak for the company. So because of that, when you're working with a corporation, when you're working with a larger organization and somebody is signing the document, you want to make sure that the person who is signing is identified not only by their name, but by their title. And part of the reason you want to include their title is because it makes it easier later on if there's a question to say what role within the company authorized the contract. The other thing is, because that person is speaking for the company rather than themselves personally, if they leave the company or if they change their name, if they take a job in a different department, it's fine. It's okay. Your contract is still completely valid because they weren't signing on behalf of themselves. They were signing on behalf of the company. And that authority continues even if they change jobs or change their names or leave the company entirely. So, the things to pay attention to in regards to signing is make sure that whomever is signing the contract actually has the authority to bind the company. And that might feel like an awkward question, but if you're dealing with an organization that is larger than 5 people, it's a perfectly normal question. So one of the things that you can do at the beginning of the process is just to ask the client, hey, what's your contracting process like? By understanding what their contracting process is like, you'll understand who it is you're going to have to interact with for the contract negotiation. And you'll also get an idea of who's going to be signing and what they're going to be looking for before they sign. If you're ever having trouble figuring out who should sign a particular document, ask yourself, what is the purpose of this document? So with a contract, the purpose is to establish a legal relationship, right? But let's say you're in the middle of a project and you have gotten to the point where you need the client to say, and you're moving from one stage to another, stage 2 to stage 3. And you've given the project manager that you're working with a list of all of the things that you've accomplished in stage 2, and you want them to sign that document to say, yes, it's okay to move on to stage 3. In that instance, what you're asking for is for the company to say, yes, these things have been accomplished and we can move on in the relationship. Because the project manager is the one who is authorized to manage the project for the company, it makes sense for them to sign that kind of document. It doesn't make sense for the lawyer to sign that kind of document because the lawyer has no idea what you've done. And the project manager is the one who has paid attention to how the project has progressed, where you are, if there are any concerns, that sort of thing. I want to make sure that I'm answering questions and I can find my, I can't find my cursor. Oh well. Are there any questions or anything that we need to pay attention to? There we go. Sorry. Does anybody have any questions about the things that we've talked about so far? Yes.
Sarah?
Yeah, I have a question related to who's signing. So is it worth putting in your contract maybe like under the signer's name that they have the authority to bind the company just so that it's noted there? Or if they're like, what's the best way to make sure that's as clear as possible?
That's a good question. Oftentimes it's mentioned in the body of the contract, and it's usually mentioned in a section called representations. Sometimes it's called representations and warranties, but oftentimes one of the representations that the company is making is that the person who is signing the document is authorized to bind the company. So that it's a really easy way of incorporating that fact, but you can do it in the body of the document rather than where the signature is.
Thank you.
Yeah.
Anyone else?
All right. So the next set of questions is all about changes, which I kind of love. Because there are always changes with contracts. One of the things I try to tell lawyers when I'm working with them and trying to help them understand how to be more helpful for their clients is that there are constant changes on a project. Lawyers often write contracts or statements of work thinking everything is going to go perfectly according to plan. There's no reason why it should ever change as long as everybody's telling the truth. I've honestly heard them say that before. There's no reason why it should change. And the fact of the matter is things change all the time. Somebody goes on vacation, or somebody gets sick, or you get into the project and you realize that they haven't told you there are 3 other systems that the website has to connect to, or there's this whole other campaign that is coming up that is going to conflict with the things you've been working on for a particular marketing initiative. So changes are going to happen. Let's just ease on into that, accept it as a fact of life, and figure out how to deal with them as best we can. One of the questions was, what does it mean, practically speaking, if a contract says additional services can't be rendered without the approval of both parties? Does that mean that you actually have to change the contract, or is it okay if the 2 parties simply agree that something is included? Can you tell the client that they can have this additional service for X amount of money? The reason that language is in a contract is to make sure that and you're usually only going to find it if you are signing your client's contract, but it's to make sure that you don't try to sneak in services to the project and get your client to pay for them. And I'm giggling a little bit because from the lawyer's point of view for the company, they're worried, right, that you could take advantage of them and charge them more than you've promised. I'm giggling because when I'm working with my clients, the last thing that they ever want to do is have to do more work for the client than they originally scoped out in the project. But one of the things I tell people, and this might help you understand lawyers a little bit, is in law school, of the many things that we get, One of them is a generalized anxiety disorder. And the reason I say that is because we are taught that if we don't anticipate everything that could go wrong and make sure that our contracts are protecting our clients from those possibilities, if we don't do that, then we're not doing our jobs. And not only are we not doing our jobs, we might not be meeting our ethical obligations. And if we're not meeting our ethical obligations, we could get in trouble and we could lose our license, and then we die penniless and alone. So generalized anxiety disorder. But sometimes if you are looking at a contract and you can't understand why would they be worried about that, think of it from the perspective of the lawyer who wrote it. They're trying to anticipate all of the potential problems and protect against them from the beginning. But so getting back to our question, what does it mean when a contract says that additional services can't be rendered without the approval of both parties? It means that you're going to have to capture any changes in writing. The contract should also have language around how changes are going to be captured. Changes to contracts are usually called amendments. Sometimes they're called change orders. It really depends on the policy of the company that you're working with. But you want to capture most significant changes, and I would say adding services or changing the cost of something is going to be a significant change in an amendment or a change order. And the reason that you want to do it that way is, one, it's in writing, and two, you get a sign off from the company saying, yes, we agree that this is something that we're going to pay for, or yes, we agree that this is something that's going to happen. Now that's perfect world, but there are also other little changes that might happen, and it might not always make sense to do a change order or an amendment for everyone. So one of the things that you can consider doing within the contract is say, any change that would require expenditure of $2,000 or more will follow the change order process. We'll have an amendment. But if the amount of money, the expenditure is going to be less than $2,000, then that's something that we can agree to over email. So you're still capturing it in writing, but you're saying, hey, there are some little changes that it's not efficient for us to do the full-blown process, but for these more significant changes, we're going to do the full-blown process. And $2,000 is just a number I picked out. It's going to be dependent on the types of projects you're doing. That number might be too low for you, or it might be too high for you. But the idea there is to differentiate between changes that are small, that are going to happen more frequently, where the doing an amendment or a change order process is going to be inefficient, and changes where it's significant enough that you want to make sure that you're capturing your client's promise to you that yes, this is okay, and yes, I'm going to pay you for this additional work. What if the client tells you that it's perfectly okay to go ahead and start or stop work or change work, that the contracts management is backed up and they're really worried about the timeline, so why don't you just go ahead and get working on that? And my recommendation there is don't. It's really better if you can enforce boundaries with your clients early on and say, no, I want to make sure that we're doing this the right way, that we both know what's going on and that that's properly captured. If you feel that it is okay to take the risk and start work without the contract being signed or without the change order being fully processed, then that's totally up to you. You know your work better than I do, and you know the risk better than I do. And that's another thing to remember, is that a lot of times when we're talking about contracts, we're talking about balancing risk. And you are honestly in the best position to know the risk that your business can manage. But with that said, if a client is saying, no, we'll just do it verbally, I don't want to capture it in writing, that to me is a really big red flag. I like to capture all changes in writing in some way, shape, or form, whether that is an email that I'm following up with and I'm saying, hey, John, it was great talking to you today. I really appreciate you taking the time on the phone. We discussed A, B, and C. You told me that it was okay to change, C to D, and I will start that process on this date. By capturing the change in email, you are basically creating an a piece of evidence that shows that there was an agreement and that you weren't just acting on your own. If you're pretty certain that the contract's going to come through, that it's just the signing process that's taking a long time, you may decide that you're going to start work. But again, I would capture that in an email and say, hey, John, you told me that it was okay to get started on this work, even though the contract won't be signed until, next week. I'm going to start doing these things, but I'm not going to be able to move beyond this point in the process without a signed contract. But one of the things I mentioned this, and I want to emphasize it, is one of the things that you're doing when you're working with your clients is establishing and enforcing boundaries. And what those boundaries do is they help you be efficient and exacting in the energy that you expend. Boundaries are making sure that you are using your energy wisely, and that you are getting properly compensated for the work that you are doing. When you start making nudges to boundaries, so when you start doing things like saying, okay, the contract said that I couldn't start work until you paid me, but you promised me the check is in the mail, so I'm going to start work. When you start making little changes like that, what that tells the client is that you are willing to wiggle on your rules. And while wiggling on certain rules might be perfectly okay, if they try to wiggle on all of the rules, that's just going to drive you crazy, because they're going to try to get away with as much as they possibly can, right? So one of the things, it can be very hard at the beginning of a project, but one of the things I encourage you to do is to establish those boundaries, enforce them, and don't apologize for it. Your client probably has lots of policies that it uses on a regular basis that they don't apologize for. Like, for instance, if they require 45 days to pay, my guess is they're not going to apologize to you because they're paying your checks in 45 days instead of 15 or 20. So it's okay to have policies. You're a business person. Your business needs policies to be effective and to work well. So use them. So these are some of the main points we talked about. You always want to capture changes in writing. Doesn't necessarily have to be a full-blown amendment or change order, but you do want to capture it. Pay attention to what the change order or amendment policy is in the contract. If it's unclear, ask questions before you have to make changes. By asking questions, you'll just have an idea of what you need to do. And be sure that you're setting expectations for revisions and what's included and excluded in the services that you're providing. This is, again, establishing boundaries, but one of the things in particular I have noticed with people who are providing creative services and the clients that they work with, their clients don't always understand what a revision means or what the process is to get the thing created. But the client doesn't want to appear naive, and they don't want to appear ignorant, so they don't necessarily ask questions. What they do instead is that they work off of their assumptions. And the problem for you when your client is working off of their assumption is that if their assumptions create totally different expectations than they should have, you end up having to have a very difficult conversation in the middle of the project, because you're having to reset their expectations and change their assumptions. And once it's in the middle of the project, they've been working off of those assumptions for quite some time. So they're kind of hardwired, and they are harder to correct if they need correcting. So one of the things that I recommend people do in their project documents is to explain what a revision is. So for instance, I did a contract for an illustrator not too long ago, and we said, there was a round of revisions after the image was penciled. And so we said changes at this stage in the process, pretty much any change is appropriate at this stage in the process. Encourage the client to provide feedback. There was a round of revisions after the image had been inked, which was being done digitally, but same idea. And we said, you know what, at this point in the process, the types of revisions that are appropriate are changes to facial expression, adding or subtracting elements from the background, minor composition changes, but we're not going to alter the entire thing. We're not going to add a character, or we're not going to, one of the things I always love is when somebody says, well, can you make that character look left instead of right? Because they're thinking about it like a picture as opposed to a drawing, which somebody has to do with their hands. So help your client understand what that creative process looks like and what's appropriate at the different stages in your work. Client management. We've been talking a little bit about this, but it's so important. I know that you didn't think when you became a creative professional that part of your job was cat herding. It turns out it is. A lot of what you end up doing along a project is helping to keep your client on the right track, helping to make sure that their expectations of how the project will progress are appropriate, that they are following your boundaries, and that the project is proceeding efficiently. One of the questions that I liked was, how do you diplomatically handle a client who's changing their mind? Specifically, they agree to one thing at the beginning of the project, and then well into it, they decide, no, I like that other thing better. One of the things that I think is helpful, and this is why I think enforcing boundaries, even unrelated boundaries early on in the project, can be beneficial for you, is your client needs to understand that their choices have consequences. So if we get to that point where they're saying, you know what, I know I picked A, but I really rather like B. One of the things that you can do is you can say, okay, well, at this point in time, since we have done all of these different things, 1, 2, and 3, changing to B is going to add these costs and this additional time to the project. If you're okay with that, we can do it. But if you want to stick to the original budget and timeline, we can't make the change at this point in the process. And part of what you're doing there is that you're providing the client an option. So you're showing them, one, their choice has a consequence, and then you're providing them the option of, are you okay with this consequence? Because if you are, we can do it. But if you're not okay with the consequence, you got to stick with what you originally decided. And offering those options, there are lots of different ways that you can do them, but I like to think of them in terms of babysitting. So I used to babysit my nephew, and I would always screw it up at the end of the night, and he would cry about going to bed, because I would say, hey, Lou, do you want to go to bed? Which is the worst question ever to ask a child. They never want to go to bed. That is never what they want to do. But my wife, she was my girlfriend at the time, but my wife started babysitting with me, and she did this amazing thing where it got to be around bedtime, and she said, hey, Lou, it's almost time for bed. Do you want to brush your teeth or get in your pajamas first? And he thought about it for a second. He was like, I'm going to get in my pajamas. And she just asked him questions all the way to the point where we were in bed. But she had established from the very beginning that that's what was going to happen, right? It's bedtime. Would you like to do A or B? And A or B was not, do you want to go to bed? A or B were things that were leading him on the way to going to bed. And managing your clients is not that dissimilar. Remember, you're the expert at what you do. They do not know how to do what you do. If they did, they would not hire you. You are the expert at what you do. You are the babysitter. You need to help get them to their goal. And if they are making choices that are leading them away from the goal that they shared with you at the very beginning, you need to help get them back on track. One of the ways that you can do that is offer options that lead them towards their goal. Another thing that you can do is, because they are not 4 years old, and you can reason with them a little bit better than a 4-year-old, is you can say, okay, you said your goal was X. If we make this change, it's going to mean Y. Are you okay with that change? And if you are, I want you to sign a piece of paper saying that you are. But are you okay with that change? Because if you are, that's great. But if they aren't okay with that change, this gives them the opportunity to reflect and say, no, my goal for this project is the same. So I need to listen to the expert advice that I'm being given and make a different choice. And what should you do? One of the other questions was, we sort of touched on it. What should you do when a project is getting off track because of what the client is or isn't doing? And in those situations, what you want to do is you want to let the client know. Don't assume that they understand the consequences of their actions. We were talking earlier about a client that signed a contract, got a project started, went for vacation. What? No, it doesn't, no, that's right there. So instead, you need to help the client understand, like, okay, because you did that, it's going to have these ramifications to the project. And they might get upset, but that's not, that's part of life. I mean, dealing with our decisions, and understanding how they impact us. And you can try to help them brainstorm different solutions, so you can offer them other options that might lead them back towards their goal. But the client does ultimately have to understand that the choices that they're making are have consequences. One of the things I do recommend is that you set your boundaries before you need them, because if you've set your boundary before you need them, it's much easier to stick to them. It's also much easier to figure out what that boundary is. If you're setting boundaries reactionary, you're reacting to what the client is doing, it might not be the boundary that best suits you and your business. It may just be the boundary that is best suiting the situation. So one of the things that you can do is to think about, like, one of the exercises I give people is think about the last 3 clients and the last 3 projects that you thought were great, that were fantastic. You loved working on the project. You were pleased with the result. It went very, very well. And then think about the last 3 projects where you hope to never work with that client again. It was awful. You did not like it. It was frustrating, and you didn't feel like you got to do your best work. What were the elements of the projects that went really well that you think supported that end result? You want to make sure that your contract and the boundaries that you're setting up support those activities. So if it's things like, well, the client paid early, or we had a meeting every week and the client was really responsive to tasks that they had to take care of, we want to make sure that our contract is clear, or our project document is clear, that we're going to have a meeting once a week, and clients are expected to follow up within so many days of receiving information, or need to provide feedback in so many days. When you're looking at the projects that didn't go well, ask yourself, what were the things that were missing there? What were the tools that you felt like you didn't have to deal with that client? And is there a way that you can incorporate those tools into your contracts or project documents? So some of it might be just providing educational information to the client. Like, let's say, I'm not picking on this particular example, but it's top of mind. But one of the things that you might do is create an onboarding document for your clients to say that helps them understand how to get the most out of this project experience. And you might address things like, don't leave on vacation. The people who are supporting the project are necessary and an important element. I'll do my best to tell you when they're necessary, but it's vital that everybody is present and participating at the time, according to the project timeline. So you might do it as just as a here's how to succeed document. You might do it within the project document itself. You might do it within that SOW and say that feedback is required within a certain number of days. You might do things that say, if they're paying you in milestones, it might say that if payment on a milestone is late, and it's late by so many days, you stop work, and you stop work until they've paid up. And that helps them understand that there are consequences to how they're behaving. But that's an exercise you might try to do. Last 3 projects that didn't go well that you didn't like, last 3 that you really liked and thought were great. What were the elements about both of those projects that contributed to the result? And then, is your contract helping you avoid those bad projects and attract and engage the better projects? This last point here is provide options, but never provide an option you don't want to follow up on. I see so many people provide options and they're like, oh, I hope they don't pick that one. If you don't want them to pick it, don't offer it. Don't feel like you have to offer 3. There isn't like a magic number, but make sure that the ways in which you are leading your client are ways in which you want to be able to follow. Now, some of those options might require additional work for you. But if that's the case, then it should come with additional compensation. So there might be trade-offs, like, okay, in a perfect world, I wouldn't want to do this, but I'm getting paid for it, so that's okay. But if there's something that you absolutely do not want to do, don't tell the client that you could do it. We've got a couple more questions, but again, I wanted to stop and see if there are questions because I have been talking for quite some time. And there quite possibly could be questions.
Anyone? I can't see everyone's faces, so I'm going to assume we're good to go.
All right. Well then, I like talking, so this is good. Oh no, I don't want my desktop. Let's see, back to the presentation. Okay. So gibberish. Why do lawyers not make sense? And why are contracts so hard to read? Part of it is we paid a lot for law school and we're still in debt. And we feel the need to prove to ourselves that it was worth it. I say that jokingly, but honestly, there are some lawyers that just like using Latin. I don't. I think a contract is a practical tool. And in order for it to be a good tool, it has to be something that both parties understand. Chances are, if you are signing a contract that your client is providing you, and the client is a corporation, it is going to be more formal and less generally understandable than other contracts might be. And part of the reason for that is that services agreement is the services agreement that the company uses anytime they're hiring any type of service. So, for instance, I used to manage contracts for the IT department at a utility, at an electric utility, and so the projects that I was reviewing SOWs and contracts for were all software, hardware focused contracts. But the services agreement that I was required to use and that I was required to send out for these projects needed to apply to any service that the utility did, including things like tree trimming to ensure that our lines stayed clear, line maintenance, like when I'm in the Pacific Northwest, so we've got a whole lot of transmission lines that are in forest areas, and the only way that you can maintain those lines is using a helicopter. So there was a section in the services agreement that talked about having proper insurance if you operated an airplane or a helicopter. And I had to send that contract out because that was the contract that the company used. And because it was the contract that the company used, not all of the terms were well suited to the projects that we were doing. My responsibility in sending it out was just to send it out. If they signed it, great. If they came back and they wanted to negotiate terms, that was fine too. And I knew there were certain terms that I could agree to exclude if they just asked for it. And one of them was helicopter insurance. But whenever somebody just sent back the MSA and signed it without asking any questions and without asking anything about that insurance section, I would usually tell the project manager to look out in the project and make sure that this vendor clearly read all of the instructions and was being very communicative, because based on how they handled the contract, it's possible that they weren't paying close attention to what it was they were agreeing to do. And if they weren't paying close attention on the contract, there was a possibility that they might not pay close attention when it got into the project itself. So if you see a services agreement that doesn't seem to be a good fit for creative services, chances are it was designed to apply to a whole bunch of different services. And because of that, it's okay to go back and say, hey, this doesn't look like this really applies to the work that I'm doing. Can we take it out? It's very likely that they'll say yes, that they'll agree, or they'll say, no, I can't totally take it out, but I can modify it in this way. And for the record, insurance requirements are one of those things. I think insurance requirements most large companies request for projects don't make a lot of sense in creative services. They may make some sense if there's intellectual property concerns, but generally speaking, you should be able to ask for modification of those limits and not have to buy copious amounts of insurance. One of the questions here was, are plain language contracts are okay? Will they be enforced by a court the same way that a more formal contract would be? And the answer is yes. Plain language contracts are okay. There's nothing inherently wrong with them as long as they are addressing all of the things that they need to address, as long as they're addressing that relationship completely. One of the biggest downfalls for any contract, whether it's plain language or formal, are assumptions. And that's where the party assumes that they have addressed a possibility or a term within the contract, but they actually haven't, or it's not very clear that they have. And this can happen when you're both very close to the project, because you get to start it's the same thing that all professionals do, right? We start speaking in lingo, we start using shorter phrases or summaries of things as opposed to explaining them. One of the things to remember is that the person interpreting the contract is not going to be you or your client. It's going to be an attorney, or it's going to be a judge. And that person isn't necessarily going to have access to information about what you were thinking when you signed the agreement. So a plain language agreement is totally okay. There's nothing inherently wrong with it. But what you want to make sure of in that situation is that you aren't making assumptions about what is addressed, or you're not making assumptions about what is understood in the contract. If you think about writing the contract for somebody outside of the situation, so somebody who's not necessarily your client, but somebody who's interpreting the document, that can help you avoid skimming over topics or not fully explaining them. That said, you don't have to get super detailed. You can assume that people understand things like, what a project is. You can use definitions within the contract to define things instead of having to explain them in great detail. So plain language is okay. One of the areas where plain language gets hard is in the areas of a contract where lawyers are very focused, and one of those areas is indemnity. I have tried to explain what indemnity means to every single person I have worked with, and I'm successful about 30% of the time. That doesn't mean I stop. I keep going until I can get them to a point where they can understand it. But part of what makes it so difficult is the words that we have legally to explain the indemnity relationship are archaic. They're not in common usage, and so it is hard to translate them into plain speak. Indemnity, by the way, it means that if a promise I make to you ends up not being true and you get hurt, I will be responsible for the harm that you suffer. So I will either pay for that harm or I will try to fix it. I like to think of it in terms of a knight agreeing to defend the castle if there is an invading army, because usually indemnity is about a third party claim, and third party just means there's you, that's party number one, there's your client, that's party number two. A third party is a party that is outside of the legal relationship of that contract. So indemnity means taking on that role of the knight in defending the castle, or in this case, the person that you are indemnifying. You are agreeing to protect them against certain harm if a promise of yours is not true, or if you don't do something you said you would do. Let's see, the best contract is one that both parties understand. So make it understandable first. don't worry about legalese. One of the biggest mistakes I see folks who aren't lawyers make is trying to make their contracts sound legal. That gets you in a lot of trouble real quick. So try to avoid it the best you can. And sometimes it is better to use lawyer language for the areas that a lawyer cares about. So indemnity is one of those examples. It is easier to use that more formal language because of that interpretation problem we were talking about, right? The person who's trying to, if there is a conflict between you and your client, the person who's going to be interpreting that contract is a lawyer. Lawyers are used to seeing things in certain ways. So if the section looks familiar to them, chances are it's going to be easier for them to interpret, and hopefully to your benefit. Dun dun. And this was basically just a question about what do I think the most important things in a contract are, and that is so hard for me to say because one, I love contracts, but two, every contract is different. It is a special, unicorn of happiness and joy, because every contract is designed to do a particular job, right? It's describing that particular relationship, and what works well for you in your relationships with your clients might not work well for me at all. One of the areas where I see this, I work with a lot of copywriters, so they're writing copy for a website or for an advertising campaign, and when you're a copywriter, it's kind of not super important to retain the legal rights to what you're writing, because you're writing them for somebody else to use, and you're writing them for somebody else to exploit and change and modify in whatever way that they feel is appropriate for the marketing that they're doing. So it's not as important that the copywriter retain the copyright to the things that they're writing. But a lot of people in creative services, they get it drilled into them that they should never, ever, 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 ever give up their copyright. And they should never, ever, 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 ever do work made for hire. And while that is totally true, if you are signing, say, like a publishing agreement for a comic, I don't want you to give up your copyright. I want you to license it. I don't want you to do work for hire. I want you to own that copyright and only give the publisher permission for it. It's not as important for the copywriter. So that's what I mean by sometimes those truths, those internet truths, always do this, never do that, don't apply when circumstances change. That said, I think a contract needs to accurately describe the work that you are agreeing to do. And that both means the work that's included in your services and the work that's not included in your services. I think it needs to accurately describe how much your services cost, so that if you're doing like a per project or a value-based pricing, so it's a flat fee for the project, it needs to include information about that flat fee. But it also needs to then talk about if they do any of that excluded work, if they want another round of revisions, or if they want to change their mind and add a new module. In the contract, it needs to address, will that work be done on an hourly basis? Will it be done, will you need to issue another quote for that work, and it's going to be a change order that you both sign? So the contract should address that in some way, shape, or form. So it should describe the work that you're doing. It should describe how much the cost is, and it should say how long it's going to last. A lot of master services agreements, so service agreements that are going to apply to lots of different projects, are going to last at least 1 year. But you might be doing just one project. So does the contract continue to apply after the project is done? It shouldn't. That shouldn't be a big deal. But you do want to be clear about how long your obligation continues to that particular client. If you don't understand why language is in a contract, ask. You can either ask your client if it's their contract, or you can talk to your lawyer, or ideally both. Your lawyer is going to give you advice based on what she knows of your situation, whereas your client is going to try to explain to you why they think that language is important. And that information can help you if you want to recommend revisions or a change to the language that better suits the the work that you're going to be doing with them. And then, as I mentioned, insurance requirements kind of have a limited applicability to graphic design and creative services. So I think I'm seeing this more often, which is why I mention it. I'm seeing really large insurance policy requirements in certain contracts, and if you go back to them and ask them for a reevaluation based on the work that you're going to do, chances are they'll give that to you. This is where I am on the internet, although social media has been hard recently. I don't know if anybody else has been in that boat, but when I am on Twitter, I am _Katie_Lane, and that's because there's a romance writer named Katie Lane. She's in Texas. I'm sure it's a lot of good cowboy stuff. And then there's on Instagram, I'm Contract Nerd, and that is where I try to encourage you to be your very best, because I know that you can do this stuff. I know it feels awkward and difficult sometimes, but I am absolutely 100% convinced that you can manage contracts and negotiations and client relationships really well. I think creative people are actually better suited for that stuff than folks who only have a logic perspective. I think your understanding of relationship is incredibly helpful for dealing with these problems. I don't know how much more time we have, but I'm willing to stick around and answer questions.
We have a couple of minutes. Yamilka, why don't you ask the 2 questions that you typed in?
Hi, so I want to know, I know that lawyers love a lot of clauses and a lot of provisions, but there's a lot of them. And I'm just wondering, does it matter where they live on the contract? Can I just sort of, does it matter?
There tends to be like a structure to contracts, and the way that I recommend you think about it is parties in the front, legal requirements in the back. So at the beginning of the contract, you're going to talk about the parties and how they relate to each other, what obligations they might have to each other. And then towards the end of the contract, it's sort of those cleanup provisions about things like how we're going to handle disputes, how we're going to change the contract if we need to change it, the fact that this is the only contract between the 2 of us and other documents aren't going to influence it, that sort of thing. So that general structure can be helpful just for readability, and it tends to be a little bit more logical for lawyers, I guess.
What about that other stuff, like let's say maybe fees, or all the graphic design type of thing, the changes, the working after hours, like would that just be in the middle somewhere, I guess?
Are you doing contracts where a project is described in the contract itself, or are you doing contracts where you have a contract and then like a statement of work or a project?
I'm trying to figure out, that's exactly where I'm heading. I want to create a master agreement so I don't ever have to think about it again, maybe once a year or something.
So with a master agreement, we're going to have more generic terms in them. So things like fee, how much something costs, that's going to be in the SOW. Things like the revision process, I'm going to put that in the SOW because it could change depending on the project I'm doing, right?
I see.
So I'm going to put those things that are project specific in the SOW. In the agreement itself, I'm going to talk about our legal relationship. So if I talk about payment, I'm going to talk about you're agreeing to pay me within so many days of me sending out the invoice. If you don't do that, this is the ramification of it. In the SOW, I'm going to be more specific about, okay, this project costs this much. This is the timetable in which you're going to pay for it. And if there are additional ramifications that you want to apply to that contract, like if you don't pay a milestone, I stop working, you could put it in that SOW.
Okay, and then my second question is, I have my company sort of broken up into like 2. One is storyboards, illustration, and then the other is graphic design, logo design, everything else. I was doing the master agreement for the graphic design of it, but now I'm thinking, should the storyboard end have its own, or should it all live under the same umbrella?
Do you have different? So let's think about this in terms of what each document is doing, right? The contract itself, it's describing the legal relationship between you and your clients, right? Does that relationship change significantly depending on the kind of work you're doing? And the answer could be yes. I don't know.
Okay. So I have to think of, okay, so I don't, yeah, it's different, two different worlds. It's two different worlds.
It's totally different.
Yeah.
It's totally different creative processes, and it's totally different expectations that you want to set up for the structure and the flow of the project. My thought is, if generally speaking, the client relationship, the business relationship, the legal relationship between you and your clients is relatively the same for those types of projects, it could work that you have a standard contract, and then the SOWs, or the project documents that you use, are different for the different types of work that you do. So for instance, I often will create a template SOW for my clients, and that means this is the structure that they use when they're doing an illustration project, and this is the structure that they use for an SOW if they're doing a corporate comics gig, because they're different processes.
Yeah.
But because they're project oriented, I capture that information in an SOW rather than the contract itself.
Okay, so then one master agreement can exist, and then everything else, whether it's storyboards or logo design.
Yeah.
Okay, thank you.
Anyone else have any questions? So if somebody wanted to have their contracts reviewed by you or edited, or, I mean, I know that you're located in the Pacific Northwest, you're in Oregon. I'm in Connecticut. What kind of, is that kosher to do something like that?
It kind of depends. I do work with people all over the country, actually all over. I've got some international clients too. Oftentimes what I'm focusing on is making sure that contract makes sense, making sure that you're communicating very clearly to your client. The thing that I can't say is how the contract would be interpreted under another state's law.
Okay.
So sometimes what I will do is I will work to come up with a template agreement for somebody, and then they'll take it to a lawyer in state and basically just pay them for an hour to say, yeah, this is fine according to New York state law, or no, you're going to want to change these two things. My recommendation when somebody does that, though, is to be really, really clear with the lawyer in their own state about what they need, that they don't need a total revision of the agreement. They just need a review to make sure that it's going to be interpreted the way that you want it to be interpreted.
Okay. So need a review based on state law.
Yeah.
Okay. And I had another question, which was, one thing that I have in my contracts is that I'm saying that everything that I design is original. And all of the images if I purchase an image, I'm purchasing it legally, etc. But if you, the client, supply something to me, you are guaranteeing that it is original. Is that the way to do it?
Yeah, no, definitely. You want your clients to promise that anything that they provide you, they either own or they have the proper permission to use. I think that is, and again, that's something that would come up in the representations and warranties section. So representations and warranties basically mean promises.
Okay.
And they're the promises that are essential to the contract. That you wouldn't sign this contract with this other person if these promises weren't true. So there are things like, the things I create for you are going to be original, or the things I give you to incorporate into the project are either going to be mine or I have permission to use, or I know that I can fulfill the obligations that are listed in this contract, that there's nothing standing in my way legally or otherwise of being able to fulfill the obligations in the contract.
Okay.
But yeah, that's an important one. The other thing that depends on whether or not you're doing a lot of copy for a client, but if you are, I usually like to say that the client is ultimately responsible for fact checking, because you're generally creating copy based on the information that they're providing you, and it's the client's responsibility to ensure that the information is accurate, that it can be, that they can use those statements, say, for instance, an advertisement or however it is that they're planning on using them.
Okay. We have another question here, which is, if you're in a different state than your client, whose state law applies?
Well, that's a good question. And the answer is whatever the contract says. So contracts will usually say towards the end what state law governs the contract. And what that means is that, sorry, my brother and sister are texting me now. What that means is if I need to interpret this contract and I have a question, what laws should I consult to make that interpretation? And so you can have a contract where the state law is California, but you're in Oregon and your client's in Washington. If for whatever reason you want California law to govern, that actually happens a lot with entertainment contracts because California law has a lot of information about how to interpret entertainment contracts. So it really just depends on what the contract says. If the contract doesn't say one way or another, it's going to depend on who sues to enforce the contract and what their state law says about it's called conflict of laws, which state's laws apply when you're interpreting something.
So we have another question here which says, stock photo rights. If I purchase them as part of a project, who owns the rights? I don't always break out the cost of them. Sometimes they're included in a fixed fee price.
So with the stock photo, you're going to want to look at the license that you're given when you purchase the stock photo. So it's the license that either the stock photo provider is giving to you or the photographer is including with your purchase. It will usually dictate how you can use that photo and in what circumstances. You want to make sure that you're purchasing a license that fits your client's use. And one of the things that you can say is that upon full payment for the project, you will transfer all licenses to elements used in the project. You'll transfer all of the licenses to your client because they're the ultimate one using it. So you want to make sure that you're purchasing for their use. And to that end, one of the things you might want to pay attention to prior to quoting out the job is, will their use require a much more expensive license than you usually purchase? If it will, it may be important to break that out for them so that they understand the value of what they're getting.
And there might be something different when I know that if I purchase images from Getty Images and the image itself costs, $500, I usually put the client's name in there as the one who purchased it. But if as a lot of us do, we have subscriptions to stock services, and they're the word's gonna escape me. Somebody throw it in there for me. They're royalty free, and so I will buy a package of royalty-free images. I have like 70 a month. And then I will resell it to my client for maybe per image $70.
Yep.
I've actually never looked at the contract to see if I am allowed to resell it, so I guess I need to do that.
Yeah, I would recommend checking it out because it doesn't come up often, but when it comes up, it's a real pain. And so it's helpful for you to be clear on what you can and can't do with certain images from the get-go. And then I also recommend keeping pretty clear records with the project files about what images you included, where you got those images, and whether or not you, like if it's Getty, whether or not you indicated the client's name on the usage material. Because that way, if there is ever a question that comes up, instead of having to recreate everything from scratch, you can go into the project file, open that particular document, and hopefully all of the links and information are right there.
Okay. Anyone else?
I have one, but I don't know if I have one. It was something that Nancy said, but actually I'm just remembering it, so I'm reading it here. I had seen a few months, maybe like a year ago, I saw something that said, to the best of my knowledge, on the contract, to the best of my knowledge, none of the deliverables will infringe on any copyright. when I had discussed with my with one of the lawyers I had worked with, he says that makes no sense. It's effectively saying, to the best of my knowledge, I did not copy from anyone else. If you copied, you will know it. So should, now my contract, should I, is that true? Should I like not have that there? Because I thought, to the best of my knowledge, it's true. Like, no?
I like to the best of my knowledge, because to the best of my knowledge is providing a bit of a caveat. Because what you're saying is, I believe everything that I have done is above board and there is no copying involved. That doesn't necessarily mean that somebody else can't claim copyright infringement. Or for instance, like let's say you license a photo from somebody, and on that license, you believe that the person that you're paying is the owner of the copyright for the license for that particular photo. But then later on, you find out that person actually took it from somebody else, and so you've passed down this problem. What to the best of my knowledge does is it basically says, based on everything I know, this is true. And so I get that lawyer's comment, because it's basically saying like, what else? What else is based off of, right? It is kind of a holdover. It's another example of the generalized anxiety disorder that lawyers get, right? Only a lawyer would look at the statement that none of the deliverables infringe copyright and think, oh God, but what if they do? But you don't know. What should I do then? I know I'm going to add, to the best of my knowledge, none of the deliverables infringe copyright. So there is some value in it, but it's sort of like,
Okay, because he also had mentioned, he said that trademark infringement, on the other hand, can be innocent, and that you do not have to copy to be guilty of trademark infringement. Using someone else's trademark or a confusingly similar mark constitutes trademark infringement, whether you actually copy that mark or developed it independently. It looks like so anyway, so that's why I was not too sure about the copyright and trademark, so.
For the record, yes, that is right about trademark, but for the record, with copyright, you can infringe a copyright unknowingly. So it can be, whether or not you intended to copy somebody else's image or work isn't necessarily the question. It's whether or not you did. And it gets very confusing very quickly because there's so many different types of work. But that's why oftentimes lawyers will add to the best of my knowledge, because then you're just establishing like, I didn't intentionally do anything that would create this problem for you.
Okay, so keep it in there.
I would.
Okay.
I mean, hypothetically speaking, not giving it legal advice.
Yeah, of course, not legally.
Okay, I'm going to say that we are done. I want to thank Katie. This was fantastic. So much great information. Again, the links are here on the right that tell you where you can find Katie, workmadeforhire.net. Thanks very much.
Thank you so much. This was great. Your questions were great, and I had a lot of fun. I hope everybody has a great Thanksgiving, or if you're not in the United States, a great Thursday tomorrow.
Happy Thanksgiving. Thank you so much.
Bye-bye.
Bye-bye.